Good afternoon. I'm Dan DeRosa with 19 News, coming to you from our digital desk. We're about to take you into a court proceeding in Cuyahoga County. This is all in regards to Cleveland police officer Jamison Ritter, who was shot and killed in the early morning hours of the 4th of July, and he was allegedly shot by Delonte Hardy. A few days earlier, he is alleged to have shot and killed his own grandmother. He was on the run. When family members spotted him, they called police. Now, he has been locked up in a mental health behavioral center near Columbus since October of last year to try and get him back to competency to stand trial for this murder. The problem is, in the state of Ohio, you can only be held for a year. Now, he doesn't get to walk scot-free, but he does get to remain in a mental institution, a hospital, for the remainder until he is deemed no longer a threat. The question has become, how much treatment has he actually received? There was a time for about 5 months he stopped taking medication, and that was apparently against the orders of the court. And in fact, the judge that you see there, Judge Ashley Kilbane, wasn't even aware that he had stopped taking his medication, was not notified. And so there has been this debate that spanned from last week until today about what is treatment and how long has he actually been in treatment. And it looks like our shot has locked up here. We'll wait to see if it comes back. But again, this is a pretty big issue because there's an entire trial for an accused murderer of a Cleveland police officer at stake here. And doesn't look like we're getting this shot back. We'll see if, and it does come back to us finally. Let's take you into court.
Ohio, this is an unreported on Lexus 4832. This was simply a trial court judge's order. And then State v. Baird, B-A-I-R-D, 2020, Ohio 2717. This was an 8th District case. It's not exactly on point, but they did cite to it, but not technically for the proposition that we're here for, but I just wanted to go over those. So State v. Melendez on page 30, the maximum time for treatment to restore the defendant's competency expires, or if it expires, or if the defendant is unlikely to become competent within the treatment time frame, the indictment should be dismissed and the defendant discharged. That's just a standard rule. However, defendant's actions can prevent the statutory time period under 2945.38 from running, which effectively tolls that period to prevent the defendant from benefiting from their own delaying actions, thus depriving the state of the opportunity to have the defendant's competence restored. And then it cites to Barker. And it says, in this case, Melendez contends that the indictment against him should have been dismissed because he was committed for treatment for longer than the 1-year period. In support of his argument that his extended treatment violated statutory limits, Melendez points to the timeline of his competency, evaluations, and treatment. And it goes through the timeline. We conclude that the trial court's failure to dismiss Melendez's indictment was not in plain error. Indeed, based upon our review of the record, it is evident that Melendez did not undergo treatment within the meaning of RC 2945.3A for longer than 1 year. And so that brings us back to where I was yesterday, that what is treatment? What is the meaning of the treatment? State v. Sowards, this was a trial court judge's order that's cited to Barker, and it says, due to the defendant not taking his prescribed medication and refusing to undergo treatment, the court finds that the defendant has only used 74 days towards his restoration period as time has told. The 74 days were previously awarded. Should the defendant continue to refuse to undergo treatment by not taking his medication, the time will continue to toll and not count towards the 1-year restoration period. The State v. Baird, the 8th District Court of Appeals case, it wasn't exactly on point. not that I don't think that for the purposes of the language it matters, but it was under the 2016 statute, so the subsection numbers are a little bit off, but essentially it shows the difference. It's one thing that I wanted to point out before, but it shows the difference in when the court is unable to determine whether a substantial probability the defendant will be restored to competency. We had already had this hearing and everybody had stipulated and agreed that the defendant is incompetent but restorable if given the treatment. That was the stipulation. This is the instance under what the subsection is now, B1A 2i. This is the instance where the judge is unable to determine that at the time, unable to determine if they're able to be restored to competency within the one year period. And basically that subsection states that the court can order continued evaluation and treatment not to exceed 4 months to determine whether there is substantial probability that the defendant will become competent to stand trial within 1 year of the defendant, if the defendant is provided with a course of treatment. So if the judge is unable, for example, at our last hearing, to determine whether or not the person is restorable, the court can then order that the defendant undergo evaluation and treatment not to exceed 4 months to then determine whether or not the person is restorable. And that's an interesting use of the language because it says not to exceed, which is different than that to me does not provide for tolling. And there's a difference in the way that was the language used. So in that circumstance, it's not to exceed. And so in that case, if somebody is held longer to determine whether or not they're restorable, for the judge to determine the initial issue. And so that's different than the phraseology that we're working with right now, which is that the court finds the defendant is incompetent to stand trial, and that there's a substantial probability that the defendant will become competent to stand trial within 1 year if the defendant is provided with the course of treatment. The court shall order the defendant to undergo that treatment. So I just wanted to kind of reiterate all of the case law and the legal analysis that went into the tolling decision, and then that brought us to let's talk to the doctors and determine what that treatment actually was at the time. So you each had the opportunity to ask questions of the doctor, and at this point I'm going to allow each side no more than 20 minutes. If you don't need it, that's fine, to give your summation of your evaluation of the doctor's testimony. So because it's your motion on behalf of the state.
Thank you, Judge. Would you like me to stay here? Or?
Whatever you're comfortable with.
So, Judge, I think the court, when we began this hearing on Friday, the court framed this issue, I think, exactly correctly when it said, really, the question is, what does the word treatment mean here? And the state has offered several exhibits into evidence, beginning with State's Exhibit 1, which was the defense's own expert report from Dr. Wood from last August, where Dr. Wood said, Mr. Hardy needs to receive psychotropic medications and a course of treatment. And if he gets both of those, it is my professional opinion that there is a substantial probability he will become capable of understanding, et cetera, et cetera. And so that's their expert saying medication and course of treatment, and they stipulated to it. So did we. The court adopted that. And so the defendant was sent to Twin Valley with that understanding. It's medication and treatment. And you heard from both witnesses who said that, especially, and I'll focus on the second witness, Dr. Dontaneni, who said Dr. Foreman was the original doctor, and the understanding of treatment was medication and the classes. and the defendant began refusing while under Dr. Foreman's care. Then Dr. Dantonetti comes in, and the defendant is still refusing. I'll pause here for a moment, because the defendant's own history shows that he knows what medications can do. They can make him competent again, just as they did in April of 24. Unfortunately, I think 2 days late, and the misdemeanor case was dismissed. He was receiving voluntary injections at Metro Hospital, as is noted in all of the reports that we see. States 1, States 2, and when we get into the reports from Twin Valley. And he refused medications beginning in April, refused on April 3rd, refused on April 9th, refused on May 9th, refused on June 28th. All of those times refusing, saying he didn't like the side effects. We know what is alleged to have happened then, shortly after his last refusal on June 28th. July 5th, he is admitted into, he's incarcerated here in the county jail and refused all medicine there too. The report notes he was just not interested in it. He never received medication in the county jail. He never received medication when he was met by Dr. Wood and Dr. Songer. And what's interesting then, fast forward to March of this year, when Dr. Dantonetti is meeting him again, and we had testimony. I believe, I can't remember which witness it was, but the testimony was he presented similar in March as he did to Dr. Wood and Dr. Songer. What a shock. He hadn't been on meds at his own refusal. And he knows what meds can do for him. And that's why I noted, and I have admitted as States Exhibit 8, 7 and 8, the reports from July. States Exhibit 7 was the letter from July 10th, where they note, he has been compliant with taking these medications since he was informed about the involuntary administration of medications as ordered by the court. States 8. I admitted this for one line. It was page 12. Dr. Dantonetti noted, after this court ordered the hospital to be allowed to use forced medications if they needed, on April, the court's order was April 1st, April 2nd, quote, well, I guess I have to take it now, unquote. Why is that important? It shows this defendant's mindset. He refused medications on purpose. He did not want them. And it's when the hospital comes to him and says, we are now allowed to use force, he was then compliant, thereafterward.
How would you respond to the defense's argument that it's his delusions that were preventing him from making those decisions?
The evidence we have is that on the occasions when he was refusing before, it's because of the noted side effects. And those side effects didn't change. He still had the same side effects after he was then required to take them. What changed? The thing that changed was he can't get away with it anymore. He can't refuse and then the hospital not give him the meds. And then we fall right into, I think, the most important part of the testimony. Both witnesses, during the defense questioning of them, independent of each other, well, doesn't it count for treatment that he was going to classes? And both witnesses said, well, it depends on what you mean by treatment, because not to us. Treatment has to involve medication. They both said it. And notably, Dr. Dantonetti, when I recrossed him did he have any plan down there that didn't involve medication? No, he didn't. All plans involved medication. So is it fair to say his treatment did not really begin until April 2nd? Yes, that's fair to say, was his testimony. And for that reason, Judge, we are requesting that all time, and I tried to hone in on this with Dr. Dantanetti, when is the last time in November he took medication? He just said at the end of November. He didn't have the date at hand. So the state is requesting from December 1st of 24 through March 31st of 25 to all be told. None of that time should count in the 1 year. December 1st of 24 through March 31st of 25.
Why did you pick December 1st?
Because I asked Dr. Dantanetti, when's the last time he took medication in November? He didn't have the actual date handy. He just said at the end of November. So, with...
He was intermittently taking, and that's some of what's unclear on the record, where he was intermittently taking medication. I believe the testimony, either was in a report or the testimony when we asked that when he did take it, he didn't take it long enough for it to, for the effects to take hold.
Right.
Because if, so there was some intermittent medication, so if we were to draw out the logical, if we were to prevail on this, but the logical thread would be back to the date that he first was not being treated, first refused. But what you're saying is that this is a case in which he was somewhat treated with medications, but you're giving it to the date of what you believe to be the last medication that he received.
So, right, the testimony was he took some, in the reports, I think, sometime in November he took some. That's it.
Okay.
But the court's right, and that's why I asked him, can we even consider he was being treated at all until April? And the answer was no.
Because if the medication doesn't take effect, then it's,
Right.
I mean,
Right.
it wasn't, the record wasn't developed, but essentially it's almost, I don't want to say it's the same as a placebo, but it didn't have its desired effect. But I understand your argument that
Right.
December 1st is maybe a more prudent date.
Exactly. I mean, I'm going to err on the side of, he did take some medication, all right? And so, if we look at, I asked the dates, and because he couldn't identify a specific date in November, which was the last day, that's why the state's asking from December 1st through March 31st. I think that's conservative in this case. To say none of that time should count. And until the legislature changes this law, where we have 1 year during which a defendant can voluntarily just choose not to take medication, and we need to come to court and ask for this time back. Until that changes, this is the system we have.
Yeah, the statutes don't directly address it.
They do not. They do not. And, the state, this community should not be reliant on any criminal defendant choosing to participate in the competency restoration procedures in order for them to be effective. And if they choose not to participate, oh well, you've got to go to court and ask for that time back and then identify all this time. When in reality, as Dr. Dantanetti said, we can't even say he even began treatment in the way they defined it, being medication and the instruction. He didn't start until April 2nd. And for that reason, Judge, we're asking you to look at this language in Barker. Where Barker notes, it's the same statute we're talking about here. Paragraph 10. Barker did not undergo treatment within the meaning of Revised Code Section 2945.38 for longer than 1 year. And they note because he refused. He refused medication. So the statutory requirement of undergoing treatment was not satisfied because treatment wasn't happening. Just like here, treatment was not happening during those months. And the state should not suffer because of that. And it is worth noting that Mr. Hardy understands the effects of medication. He's been refusing it long before he was arrested in this case. And he understood that prior to refusing it, that it was working. And with that in mind, when they come to him on April 2nd and say, now we have authority to force if we need to, that's why him saying, well, I guess I have to take it now is so instructive of his mindset. Because, like I said, the side effects didn't change. The reasons he was refusing didn't change. They were still there. But his attitude changed because he couldn't benefit from it anymore. And it's for that reason, Judge, that we ask that the state's motion be granted and that that the 1 year be adjusted to reflect when he was actually undergoing treatment, as the statute requires. And if there's any time left, I'll reserve it for rebuttal if possible. Thank you.
There is. On behalf of the defense.
Good afternoon, Your Honor. Your Honor, this is an extraordinary remedy that the state is asking you to order here. And extraordinary remedies should only be undertaken in extraordinary cases. Barker was an extraordinary case. So were many of the other ones that you talked about. Notable that there are only about 3. The fact that there are only 4 in the entire state proves that this is, and these issues only come up in the extraordinary case.
Yeah, and you know, it's hard to record essentially things that are not in front of this court, but as a matter of practice, a matter of general practice, these don't come up that much because 5 months of not being notified occurs within a year. And that's just based upon experience, but what do you mean by, they're rare.
They're unusual.
They're unusual because of the common practices of being alerted closer in time to delivery of somebody not taking medications, and because of using medications.
That's correct. And with the court's permission, I would like to talk about some of those issues.
Sure, go ahead.
You know, we talk a lot about Barker. I just think it needs to be that Barker was deliberately and consciously attempting to undermine the legal process. He was filing meritless appeals. He was not only refusing to take medication, he was doing consciously everything he could think of to run out the clock. That is not what you heard from the doctors about what Delante's situation is.
Can I, for the purposes of the statute?
You're the judge.
Well, did it to the state when they're there, instead of moving on and then I forget what I wanted to get frustrated by it, but I like to handle things as they come.
I'm used to it, Judge.
So, do you think for purposes of the statute, it matters what the subjective motive is for the reason of not taking the medications? Because I remember there was a word, I think it was I think it was purposely, I think there was another word used, maybe it was in the Barker case, but it was
Because what you heard was that Delonte is a very sick young man. He suffers from severe schizophrenia, and one of the symptoms of that illness is a delusional belief that he doesn't need medication. So this goes to what the intention is and what's causing the delay. He's not someone who's deliberately and consciously trying to undermine the legal process. He's a sick young man who doesn't think he needs medication. Those are two very different situations. The state is attempting, I think, to conflate those two. I'm urging you not to.
I'm not so sure that I'm looking at the objective reason why the medical
means that what happens when someone is committed for restoration is the doctors are entrusted to employ the strategies that are in their best practice and their experience as physicians to overcome the kind of reluctance that people like Delonte probably exhibit all the time. So the doctors are in the best position to make that determination. There's a reason why the statute probably doesn't, there's a reason why the statute doesn't say the judge, you should check in every few hours or every few minutes or every few days to see what the doctors are doing. The statute trusts the doctors to treat a patient the way they see fit, to utilize the strategies to overcome his medication reluctance, to get him invested in his own treatment, to try to convince him that it would be in his best interest, because they think if you do that, it's more likely to be successful. We heard a little bit about this.
What happens in the situation where a doctor is ready meds from that doctor starts their evaluation over? What if Dr. Dantonetti that is one aspect of all of this, but
Yeah,
there's got to be something that tethers.
that would be
the
a highly
timing to the
extraordinary
treatment.
situation, Judge,
But
just like I talked about.
I didn't hear what you said. That would be what?
I believe that what the judge is referring to would be a highly extraordinary situation, as I opened with.
I think
that sort of thing would be. Intermittent medication compliance, and you have the doctors doing what the doctors think they need to do. What the state is really asking you to do here is, let's just be clear about what they're asking. They want you to second guess what the doctors did and the course that the doctors took, how long they took to come back to you, what they were doing in the interim. They think it should have been different, and they want you to say you think it should have been different. I don't know of any case in Ohio, Barker or any of the other ones, that says if you don't like what the doctors did, you can toll the time. This would be the first.
That's not what Barker is saying.
Barker's not saying that at all.
But nobody's saying that.
Nobody has ever said that, Judge. That's my point.
No, nobody's saying that the judge, well, first of all, the judge ultimately determines competency, but legally. But what they're saying is that if the doctor, because the doctors are saying that it requires, and it has always required, medications, pharmacological treatment. They're always saying that. Nobody has ever wavered from that from the time where he was in the Cleveland case to now. So nobody's replacing the doctor's opinions at all. What they're simply saying is, and I have to say, Dr. Dantonetti, when you guys were examining him, he said something when you asked him, well, wasn't he being treated? And he said something to the effect of, well, not really, because he wasn't receiving his meds, so he really wasn't being treated. I'm sorry, I forget the first doctor's name off the top of my head, but said, well, it depends what you mean about treatment. And I'm just sure that I follow the case law and I'm not trying to replace my judgment for what I think is treatment. The doctors are saying what treatment is. And the statute, again, is pretty clear when it comes to, it says if the defendant is provided with a course of treatment. And there's a logical thread there, I have to say, because even by your own admission, the time, in your own agreement, the time wouldn't start until they're delivered, until the defendant is delivered to the institution for treatment. And there's a logical reason for that, is because while they're awaiting transport, they're not being treated pursuant to, you know, the appropriate treatment, which in this case, your doctors agreed. So, you know, it's kind of, you're stating that logical thread should somehow be broken because somebody who's incompetent is refusing treatment when you're already agreeing that treatment doesn't actually start until they're delivered. But what you're asking this court to do is say that treatment does not include medications, and therefore the time should run. And the doctors are saying treatment does include medications.
I do object to that. I feel like, you know, that came up several times. on Friday. I even said something about it at the sidebar. Maybe I was a little annoyed when I said that, and I apologize. We are not saying that he doesn't need to take medication.
I understand that.
I just make that very clear. What we are saying is the doctors are vested by the statute with the discretion to give him the medication in the way that they see fit to treat his illness. They are the ones in charge of what's going on there. And I just want to be, I've said everything I came up to say. If you have any other questions, I'll try to entertain them. But I feel like what I want to close with is to say, if you do what the state is asking you to do, you will be the first judge to do that. Nobody else has said, I disagree with the way the doctors handled his treatment, therefore I'm going to toll the time. That is a first.
That's actually not true.
I believe that is true.
I just read one other judge that followed Barker and did the same exact thing. I can reread it again. And again, it doesn't matter if I'm the first or last. I just do what I believe is right according to the law. So
We disagree with that, Judge. We would ask you to follow the statute and not to grant the state's motion.
okay.
Thank
And
you.
so again, I'll read State v. Soward's 2021.
I'm sorry, you said what?
State v. Soward's, S-O-W-A-R-D. Due to the defendant not taking his prescribed medication and refusing to undergo treatment, the court finds that the defendant has only used 74 days toward his restoration period as time has told. So another judge has done that. And then State v. Melendez. Again, it says, however, a defendant's actions can prevent statutory time period from running, which effectively tolls that period to prevent the defendant from benefiting from their own delaying actions, thus depriving the state of the opportunity to have the defendant's competency restored. That was a 2025 case. This came out in June of this year. They upheld the dismissal. They upheld the denial of the case being dismissed. So again, we conclude that the trial court's failure to dismiss Melendez's indictment was not plain error. Indeed, based upon our review of the record, it is evident that Melendez did not undergo treatment within the meaning of RC 2945.38 for longer than 1 year. So I don't know how this was missed the last time that 3 cases had cited to it, even though they're not all of them exactly on point, except maybe for Soward's, but that's unreported. I'll let the state and then any response from the defense as well.
Thank you, Judge. Your Honor, defense just stood here and said, you know, the reason he's refusing is because he doesn't know he is sick, which is a common symptom. I'm not sure the testimony bears out that that's exactly why he was refusing. There were a lot of questions were, isn't it common for people in his situation to refuse because they don't know they're sick? We didn't get all that about Mr. Hardy. What we have are these reports. And I'll note, in State's Exhibit 4, we have what Dr. Dontanetti wrote to us. Hardy refused medications while being treated by Dr. Foreman and again while being treated by Dr. Dontanetti. In January, Dontanetti, quote, attempted to encourage him to take his prescribed antipsychotic medication, unquote. In February, Dr. Dontanetti noted, quote, reluctant to consider taking any psychotropic meds at this time, unquote. In March, he just states, quote, refuses to take meds, unquote. He's not being treated. Plain and simple. Both doctors said treatment is medication and these other things. He's not being treated because he's not taking meds. And if there really was a concern about Mr. Hardy's well-being, and they shouldn't even object to this motion. Because what's happening here is he's actually being medicated now. And what's interesting is, and we heard this from the last witness, it's not even injections at the moment. because since April 2nd, he has not refused at all. Ironic if the reason is because he doesn't know he's sick. He has not refused once since April 2nd because he knows it's injections if he does. And it's not injections now. Injections are what worked to make him competent last January. And, you know, they say trust the doctors. And I'll just say this, thank goodness there's a statutory requirement that they provide this court a report every 6 months. Because if we didn't get one in March, who knows when they would have asked to give forced medications. And if what they say, what the defense says is true, that them requesting him to take meds is treatment, that clearly is, for lack of a better term, the inmates running the asylum. If they just get to choose in this situation when to take meds, and if they just refuse, and it's going to count, because they need to convince me, and I guess I'm not convinced today. Well, it all counts, because the part of being convinced is part of being treated. I don't think so. And that's why I went back to their own doctor's opinion, which was he needs medication. They submitted that. They agreed to it. Frankly, I think they should be stopped from arguing against it. They say they're not arguing against it, but they want this time he refused to count as him being treated. They want him to benefit from not getting medication for 4 months and to have that count against the state of Ohio. That's patently unfair. And this court has authority to do this from the cases that we've cited, the court has cited. And with that, we'd ask you to grant this motion. You know, I think he has not been treated since October. But I don't know what the case law says about the intermittency, right? And so, like I said, being conservative, that's why I asked Dr. Donnetti those questions. The state should certainly receive, and I asked him, December, did you take any medications? No. January, no. February, no. March, no. All of that time should be given back to the state under this 1 year that this statute gives us. Thank you.
Okay. Did the defense like to respond before? Okay. All right. So having reviewed all of the statutes, case law, at this point, there are 3 Ohio cases that recognize a tolling of the statute, one way or another. And I stated those: Melendez, Swords, and Barker. We have examples of where there's not tolling, which I cited as how a statute can be written, the Wisconsin case, and then also the difference in the language, which I reviewed under Baird, the 8th District case, in a different circumstance, in a different analysis, where they used the phraseology for the continued evaluation and treatment to determine whether there is substantial probability that the defendant will become competent, which is not our case here. But the language used when it applies to the timeline for that is not to exceed, in this case, 4 months, as opposed to whether or not the defendant would become competent to stand trial within 1 year if the defendant is provided with a course of treatment. And again, that's subsection B1A, little I, and then subsection C, no defendant shall be required to undergo treatment, including any continuing evaluation under B1 for longer than whichever of the following periods. And again, it's tied to treatment. The doctors, in my opinion, were clear that treatment includes medications. One of them even said he's not even sure if it could count as treatment because he didn't receive the medications. The defense's doctor agreed that medications were necessary for treatment. I'm not sure that it matters for purposes of the statute, the reasons why or the motive behind why a defendant is not being treated or not taking the medications. And if you're following the logical thread here, statutes should always be construed to prevent absurd results. And in this,
To prevent
absurd results, absurd outcomes, and to allow 5 months to pass, and specifically in this case, when you do have the evidence of prior treatment, restoration to competency, and in this case, you also have a change in doctors, which, there's got to be an equitable tolling. All of the language in all of the cases the 3 cases in Ohio that have ruled on this issue, or at least close to this issue, again, Barker rejected the argument that treatment may include alternatives other than medication. Therefore, he asserts that his refusal to make medication was not a refusal of treatment. They rejected that argument, the specific argument that was made. And all the language in Barker states that we see no error in the trial court's application of equitable tolling principles to prevent Barker's own actions from depriving the state of an opportunity to have his competence restored. And I don't think that it requires a malicious intent to do so. The fact is that the statute simply requires treatment. And if the defendant is not receiving treatment, it's according, and again, as the other cases state, that it's not treatment within the meaning of the statute. And because the statute doesn't give any guidance about when or a doctor should be alerting the court, 5 months was, in practice, I believe, a shock to everyone. The forced medication issue was something that we all agreed upon. There was not an issue with everyone, as everybody said, that he requires medication in order to be restored to competency. And if the state has the obligation to restore the defendant to competency via treatment, it must have the time and ability to do so. And again, if he has been treated for a year the way that everybody agrees he needs to be treated and he's still not competency, the statute has contingencies for that. But he was not treated during this time within the meaning of the statute and within the meaning of what everybody agrees to be the definition of his necessary treatment. So I am going to grant the state's motion. I'm not going to, the logical thread would be to have that told back to the time frame where everybody agrees that pharmacological treatment is necessary, which would be once he was delivered to the institution. But the record really wasn't developed, I believe, as much regarding how many times he took his medication, whether it was effective. Does that count as treatment if there's intermittent treatment? I'm specifically not going to make a determination based upon that. I'm not going to make a ruling upon that. And the state, and prudently, is only requesting December 1st. And so I'm going to toll back to December 1st. I don't know if this is an interlocutory appeal matter. I don't see anything. I know that the forced meds obviously is. So you guys can let me know how you wish to proceed. The state also filed a new motion. Did you want to present to that? Are you prepared to respond to that?
Not at this time, Your Honor. We just received it yesterday.
Okay. We can briefing schedule for that. How long would you like?
We're respond within 2 weeks, Your Honor.
Do you anticipate a reply?
I doubt. And just to clarify the court's order, is that December 1st through March 31st then?
Correct. So 2 weeks brings us to about September 30th, October 1st. When would you like to set the next hearing?
Judge, tentatively, can we propose the 30th, but we'll confer with Mr. Ingles, who's in trial right now?
Yeah, tentatively for September 30th. And then if you could also at the same time alert the court of your intention. I don't know if this is appealable, if this is a final appealable order. Just to make sure that you inform the defense if you can as soon as possible so that if they have a contrary position, they can make that known. But again, we're dealing with some of these issues of first impression. So anything else for the record?
Just to let the court know, I'm likely going to be in trial on the 30th, but we can work around that. But I think myself and Mr. Cleary can
Okay.
be ready.
Anything else from the defense?
Nothing right now, Your Honor. Thank you.
All right, thank you.
I get a mic check on mic too? All right, checking the mic. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. All right, thank you. This is hot.
First, we're going to the first 5 months. He was not taking his medication. He's actually refusing to. Finding that shocking not only the judge, but both sides of this case. Now, the heart of the hearing today was Ohio law. Says that he had 1 year to become when the date which is dismissed. Now, originally, the 1-year deadline was next month. However, when it came out, the party was refusing this and expressing he wanted a new deadline. Party that hearing is typically set for the year. Hey, Zach, can it go in?
Sorry.
Can it go in?
No, you're good.
No, saying can it go in?
Oh, yeah, it's yeah.
Oh, okay.
We gotta go, Arya.
Okay. Perfect. Thank you. Oh. Cars. You said the what?
We'll go up the steps.
Okay.
Do you want me to roll on this? It doesn't hurt to, but if you think it'll be similar is all.
The tag, definitely, maybe.
Okay.
I just feel like I'm saying a lot of information in this intro that I won't say
Okay.
later.
Yeah, that's fine.
Actually, we might.
Okay.
We might. past 9 months, Hardy has been in a behavioral facility getting treated for his schizophrenia in hopes of being competent enough to stand trial. But we learned for that first 5 months, he wasn't taking his medication. He was actually refusing to do so. This not only shocked the judge, but both sides of this trial. Now, the heart of the issue today, I'm just worried about them not taking VO when I need them to take VO. Because I'm going to have to look down.
Okay, VO, I'll give you this for VO.
Well, no, I'm worried about them.
I know. Yeah, I know what you're talking about.
I mean, it's kind of dumb, but I feel like if you can get off me and zoom into the door.
Yeah, take half step this way.
This way?
Yeah, right there. Okay, cool. Yep, and then I'll just go to the
just
justice
so whenever
center
they
side.
take it, like, I can still look down, because
Okay.
I've only memorized.
Yeah.
So.
No, you're good. Yeah, I'll just be on you for like 4 or 5 seconds, and then we'll go off.
When you hear me say, like, but for the first 5 months,
For the first 5 months.
you
Okay.
can start moving.
All right, 30 from break.
Getting treated for his schizophrenia. But for the
About a
first
minute.
5 months of that, he wasn't taking his medication. He was actually refusing to do so. This was a big shock to not only the judge, but to both lawyers in this case.
I represented families just like yours for over 4 decades. If you need me, call me. You know I'll be there for you, and I'll make them pay. In the meantime, I'll keep an eye out for you. I've represented families just like yours for over 4 decades. Listen, if you need me, call me. You know I'll be there for you, and I'll make them pay. In the meantime, I'll keep an eye out for you. I've represented families just like you. I've represented families just like yours for over 4 decades. Listen, if you need me, call me. You know I'll be there for you, and I'll make them pay. In the meantime, I'll keep an eye out for you. I've represented families just like yours for over 4 decades. Listen, if you need me, call.
From Cleveland's most accurate weather team, this is 19 First Alert Plus. Sponsored by the man that makes them pay, Tim Misney. From Cleveland's most accurate weather team, this is 19 First Alert Plus. Sponsored by the man that makes them pay, Tim Misney. From Cleveland's most accurate weather team, this is 19 First Alert Plus. Sponsored by the man that makes them pay, Tim Misney. From Cleveland's most accurate weather team, this is 19 First Alert Plus. Sponsored by the man that makes them pay, Tim Misney. From Cleveland's most accurate weather team, this is 19 First Alert Plus. Sponsored by the man that makes them pay, Tim Misney. From Cleveland's most accurate weather team, this is 19 First Alert Plus. Sponsored by the man that makes them pay, Tim Misney. Pay, Tim Misney. Cleveland's most accurate weather team. This is 19 First Alert Plus. Sponsored by the man that makes them pay, Tim Misney. From Cleveland's most accurate weather team, this Now your 19 First Alert forecast. Now your 19 First Alert forecast. Now your 19 First Alert forecast. Now your 19 First Alert forecast.